the President issued a proclamation extending the suspension of entry of certain immigrants and expanding the suspension of entry to include certain non-immigrant workers. The proclamation takes effect at 12:01 a.m. Eastern Time on Wednesday, June 24th, 2020, and will remain in effect at least until the end of the year. This travel ban is one of the most sweeping suspensions of legal immigration into the United States, impacting families, diversity lottery recipients, U.S. businesses, churches, and universities, just to name a few. AILA is gravely concerned that this travel ban in no way supports the administration's hollow claims that it will preserve jobs for American workers, as many of the non-immigrants who have been banned are filling jobs that U.S. workers cannot or will not fill. We believe that this ban will stymie economic growth and innovation when it is most critically needed to recover from a global health and economic crisis. This proclamation extends, effective immediately, Presidential Proclamation 10014, issued on April 22, 2020, which suspended the entry of certain immigrants into the United States. The June 22nd proclamation also suspends the issuance of visas for those seeking entry pursuant to an H-1B specialty occupation visa, an H-2B temporary non-agricultural visa, an L intercompany transferee visa, and a J exchange visitor visa if the foreign national is participating in an intern, trainee, teacher, camp counselor, au pair, or summer work travel program. The proclamation also suspends the entry of any foreign national accompanying or following to join the individuals named previously. The proclamation will only apply to an individual if he or she is outside of the United States on the effective date of the proclamation, does not have an immigrant or non-immigrant visa that was valid on the effective date of the proclamation, and does not have an official travel document other than a visa, such as a transportation letter, boarding foil, or advance parole document that was valid on the effective date of the proclamation or issued thereafter, permitting the individual to be admitted to the United States. There are a number of individuals who are exempt from the proclamation, including lawful permanent residents, the spouse or child of a U.S. citizen, individuals who will be providing temporary labor essential to the U.S. food supply chain, individuals whose entry would be in the national interest, including those who are providing services related to the combat of COVID-19, and, importantly, due to litigation brought by AILA and its partners, children who would age out for visa eligibility due to the suspension. For the full list of exemptions, please review the summaries prepared by AILA and the American Immigration Council for the April 22nd and June 22nd proclamations. Although these bans are set to expire on December 31st, they may be modified or extended based on review and recommendations of the Secretary of Homeland Security in consultation with the Secretaries of State and Labor. In addition to the suspensions of entry of certain immigrants and non-immigrants, this proclamation orders additional steps to be taken by various federal agencies, including setting up methods to reduce the risk and spread of COVID-19 from individuals coming into the United States, and ensuring that an individual has had their biometrics, including photographs, fingerprints, and signature, captured before they can apply for a visa or admission to the United States. The proclamation also orders various federal agencies to issue regulations or take actions that would ensure that those who have already been admitted or are seeking admission as an EB-2 or EB-3 immigrant or as an H-1B non-immigrant do not limit opportunities for U.S. workers. This will include issuing interim final regulations, amending the H-1B program to always require a degree, prohibit speculative employment, limit third-party placements, and redefine the employer-employee relationship. Federal agencies will also be required to undertake investigations of labor condition application violations and prioritize the highest paid H-1B workers in determining who can file an H-1B petition, as well as revise the prevailing wage levels to require that workers be paid at least at the 50th percentile. And finally, agencies would take steps to eliminate work permits for individuals with final orders of removal or those who have committed a crime or are inadmissible or deportable. To learn more about the proclamation, please check out AILA's dedicated resource page, which includes the text of the proclamation, as well as AILA's press release, in-depth summaries, and frequently asked questions. This is where you'll be able to find the latest on litigation and other important information. We know that AILA members and their clients have a lot of questions regarding how these travel bans are being implemented. AILA is committed to continuing to monitor the implementation and impact of this proclamation, and we will be here to support you as immigration goes through yet another seismic shift. Our CBP and Department of State liaison committees have already begun collecting and raising questions regarding implementation to the respective agencies. AILA has posted a survey for members on its website where you can submit reports or questions to be reviewed by the committees as they continue to determine next steps. As we receive new information, we will update members and resources on the dedicated page. We are also planning free member roundtables, which will be posted as soon as the dates are confirmed, and are developing an informational flyer that can be shared with your clients. And last, but certainly not least, AILA and the Administrative Litigation Task Force are working with our partners to consider various avenues to challenge these travel bans and expected regulations to ensure that justice and the rule of law prevail.